How are we doing, pre-litigation community? Wanted to do a quick video on the FCRA's requirement for reasonable procedures. A lot of people focus on the accuracy requirement that the credit bureaus are supposed to report maximum possible accurate information. But that's really only half of the requirement. The other half of the requirement is that they have reasonable procedures to assure that maximum possible accuracy. And then when it comes to the dispute part, they're supposed to conduct a reasonable reinvestigation. And why is this important? This is important because how do we send our disputes? If we're just going into the credit repair software, firing out some sort of a, generic letter, we're not really notifying the bureaus of anything substantial. What are we giving them to conduct a reasonable investigation? In other words, put it a different way, if we don't like the outcome, can we really say that they were unreasonable? Let's take a look at this and kind of see what we're talking about here. So do a little screen share. All right, so number one is we have the FCRA 1681E, where we've got their compliance procedures. Again, it's procedures, right, is the name of the section here. And 1681EB is where that accuracy requirement comes in. And the bureaus are required to have reasonable procedures to assure maximum possible accuracy. So the information can be inaccurate, but if their procedures were reasonable and that was the best information they had, then I don't really think you've got a problem, right? Because they're supposed to have reasonable procedures to assure maximum possible accuracy. And so that's where Metro 2 as the industry standard data format comes in, is because as part of their reasonable procedure requirement to assure maximum accuracy, they created an industry standard format as part of their procedures. So it's important to understand that the FCRA is a procedure-driven statute. So this is where the accuracy requirement comes in. What about when we dispute it? So when we go to dispute it, this here is 1681I, which again is procedures in case of disputed accuracy, right? And your basic reinvestigation provision requires that, let's see, that they conduct, where is it? Free of charge, conduct a reasonable reinvestigation. So they should conduct a reasonable reinvestigation. So again, the idea is if you send a dispute letter to the credit bureaus and you don't really give them substantial information to figure out what's wrong with it, have you really put them in a position where you can hand a thing off to an attorney and the attorney is going to say, yeah, well, clearly there's liability, because you're not going to be in a position to sue them for inaccurate data. What you have to do is argue that their whole reinvestigation failed. Now, of course, that ties back to the accuracy. Well, your reinvestigation failed because the information was inaccurate, but we put you on notice of the errors and you didn't fix it, so here's why, versus we just gave you a letter that said prove it and remove it, and you didn't remove it, and I'm not happy. Well, I mean, can we really say that their reinvestigation was not reasonable? So the takeaway here, guys, I wanted to just share this with you because I think a lot of people get caught up on whether it's accurate, whether it's inaccurate, and of course, that's super important. But we have to understand our part and the consumer's part in the whole process. The bureaus are required to have reasonable procedures to assure maximum accuracy. It's your duty to work with the consumers to give them enough information to conduct a reasonable reinvestigation. So next time you're setting up letters and you're trying to figure out, is this a good dispute? Is it a bad dispute? Just kind of think about that. If you were reading the statute and trying to argue that they didn't do a good job, could you truthfully say, hey, what you gave them, you would argue that their procedures were unreasonable? Let's see. Ali from Cali, hello, how are you doing? All right, rock on. Let's see. We've got so many people do a generic letter, and there are so many people interpreting things and spreading wrong information like a disease. Well, that's why we bring this information to you, is because the only cure for the disease is the anti-disease, and knowledge is power. So no, I appreciate that. Let's see. I don't even know if anti-disease is a word, but to hell with it, it is now, right? Let's see. Good info, Steve. We have to build the case so lawyers will take an FCRA case. That's so true, right? And Again, so if you're looking to build a case file, don't get frustrated when the lawyer says, I don't really like this. We need to look ourselves in the mirror and say, how can we get better to better align with what these lawyers are looking for, right? So remember that the bureaus are held to a standard of reasonableness. They're not really held to a standard of accuracy per se, if that makes sense. The accuracy and their liability for not being accurate ties back to the reasonableness. Were they reasonable when they first inserted it? Did they do a good job to make sure it was maximum accuracy? And then were they reasonable when they investigated? And if you just gave them a garbage letter, that's probably the kind of thing that an attorney would say, we can't do anything with this. On the other hand, if you take the time and you put them on notice of actual errors and they don't fix it, and especially if you give them a copy of the credit report in the dispute as actual proof, and you tell them in the letter, hey, here's what's wrong, and here's proof of it, whether this is something from the creditor that shows it's wrong or your own information that is clearly illogical, it's an entirely different dispute, which puts them in a whole different position of reasonableness. So let's see here. All right, Steve, what are your thoughts about certain people bringing in Truth in Lending Act and UCC into the equation when it comes to the FCRA or the FDCPA? A violation, can truth in lending be tied in? Well, the whole thing is you want to put them on it. So that's a really good question. You want to make sure that you are not combining or conflating the issues. So Truth in Lending Act is going to be one issue. So from a credit reporting perspective, my question to you is, how would a truth in lending error be a credit reporting error? I mean, if you're like, well, Stephen, the interest rate is not being calculated correctly. Well, okay, that's a truth in lending problem. That's not a credit reporting problem. I mean, if the balance and the payoff are what they are, if they're accurate balance and payoff, it's just that they're being calculated wrong because maybe the truth in lending calculation was wrong. That's not really a credit reporting problem, right? As far as UCC, again, so if they didn't give you some sort of a notice, to redeem or something with a foreclosure or, excuse me, a repossession, how does that become a credit reporting issue? I mean, it may mean that maybe it was an unlawful repossession. So, I mean, are you trying to make the argument, well, because it was an unlawful repossession, it shouldn't show as a repo in the credit report? That's going to be a far stretch because, I mean, the precedents are kind of clear where legal conclusions are not really FCRA issues. And what I mean by that is, if you're like, well, it was an unlawful repossession, you got to argue their whole repossession thing versus the FCRA reporting is wrong because there's clearly something wrong with the reporting. So now, all that being said, hey, it's all about the game of leverage. So I am all about throwing in what you can. I'm all about using the power of attorney, calling the furnishers, writing to the furnishers, writing to their executives. The other thing is most truth in lending provisions, I believe, only have a 1-year statute of limitations, if I'm not mistaken. So, I mean, from an actual enforceability perspective, there's not a whole lot there. I think it's 1 year. Don't quote me on that. Maybe it's 2. But yeah, as far as pre-lit, it is all about how can you make a well-crafted argument. So good question there. All right, look, I keep on losing my head here, guys. These things get bigger. I'm going to have to climb up above. All right, let's see. How do we take this and prove these errors are potentially affecting the score, thus causing damages? Could it be argued some of the errors cause small score problems? The difference between a 615 and a 620 is approval or denial. So, well, I mean, I guess your question of how can it be argued and proven? I mean, ultimately, those things aren't really argued or proven until there's a lawsuit, and then you usually have experts on both sides. Like we have a guy, Doug Miner, he's an credit damages expert witness, and we've got shows with him that we do in here. But now to that point, what you can do is you can take publicly available information. You can take news articles and things that say, hey, the FICO score is based off of the credit information, and so inaccurate credit information, junk in, junk out, is going to affect the score. So it is a hard thing to kind of say, well, if you've got 20 charge-offs, this one trade line has affected your credit this much. But again, if if you're all about working the pre-litigation leverage, it is no secret that the credit scores are based on the data. And so if the data is wrong, you can certainly make an argument that the score is not going to be as clean as it should be, which goes back to tying it to credit errors. So your foundation there is to actually have a good dispute. Hey, man, these things are wrong, and here's why. So good question there. Let's see here. Thanks for your time, Stephen. Great info as always. All right, excellent. So we love you guys. All right, so that being said, we're going to sign off on this one. And so hopefully the whole reasonable procedures part of the FCRA is now on your radar, so you can make more effective disputes. And we will see you guys on the next video. Take care.